Namaste. This is Advocate Surya Kundeti. Today, our topic in Code of Civil Procedure 1908 is commercial codes. Commercial codes are playing a very vital role solving disputes related to commercial contracts under the Code of Civil Procedure 1908. So before I detail into the class, I would like to request you as usual. These classes are dedicated to an charitable trust, and this trust is involved in nutritional benefits, enriching the nutritional benefits of school-going children and also for their education. As a gesture, I request you all to please donate 59 rupees towards charitable trust through the UPI 9949398998, and at the end of this class there will be a display of QR code where you can use the QR code to scan the UPI and make the donation of 15 rupees. In addition, most important point is, please do not forget to subscribe to my YouTube channel, because the more the number of subscriptions I receive each and every day, it is going to be directly proportional to my encouragement for doing more and more legal classes. Thank you very much. And today's our topic is commercial courts. In commercial courts, we have commercial disputes. Of course, in commercial courts, the only jurisdiction of the cases what are going to be listed is commercial disputes. Meaning of commercial disputes is commercial disputes are disagreements or conflicts that happen during business and trade activities. They can arise from a wide range of commercial transactions such as breach of contract, which is when one party fails to fulfill their obligations in a business agreement. Other one is partnerships or partnership disagreements, conflicts among business partners over management, profits or dissolutions. Issues with goods and services is also one point where you have an opportunity for commercial disputes. Disputes related to the quality, delivery and payment for goods and services as well. Financial disputes also can fall under commercial disputes segment. Arguments over loans, insurance claims or other financial arrangements are also fall under this category. In essence, these are legal or business conflicts that originate from the regular course of commercial activity. So, in the same line, why commercial disputes are special? Commercial disputes are treated differently from other legal cases because of their significant impact on the economy as well as societal impact. In simple, it is called as impact on economic impact. High stakes. They often involve large sums of money, making the outcome critical for the financial health of businesses involved and as well as the society as well. Society means everybody. And broader economic impact. The resolution of these disputes can affect business confidence, the stability of financial markets and the overall economy. A transparent and efficient legal system for resolving these conflicts encourages more business activity. And impact of delays. Long delays in settling these disputes can be very damaging. They can tie up capital, create uncertainty and ultimately discourage investment and hinder economic growth. So in the same lines, we have the next point as need for expeditious disposal. Why speed is very crucial in this disposal of such commercial disputes? Commercial disputes need to be resolved quickly because they have a direct and significant impact on the economy. Unlike a typical civil case, which might affect only the individuals involved, a prolonged commercial dispute can have wider negative consequences. The text identifies two key reasons for this one. The first one is the economic impact. When the commercial dispute drags on, it can tie up with a significant amount of capital and resources. Business might become hesitant to invest or enter into new contracts, and this can slow down economic growth. The text states that these disputes influence the economy and therefore cannot be dragged on for years like ordinary civil cases. This urgency is a key difference between commercial and civil litigation. The next one is trust and confidence, the fundamental factors of doing business. The legal system that cannot resolve commercial conflicts in a timely manner erodes trust. When business and investors are confident that their disagreements will be handled fairly and quickly, they are more likely to engage in trade and business. This boosts trade and ensures smoother business operations. Conversely, a slow system can deter investments and make business less willing to take risks. In short, the swift resolution of commercial disputes is not just about fairness for the parties involved, it's a critical component of a healthy and dynamic economy. So like this, the next coming topic is commercial contracts is steps taken by the parliament that falls under the commercial codes. To ensure commercial disputes are resolved quickly, India's parliament has taken two key steps, very important steps. First one is creating specific laws and setting up specialized courts. So what is the special statutes? Parliament has enacted specific laws or special statutes tailored to address certain types of commercial disputes. These laws are designed to provide a clear legal framework and streamline the resolution process, making it faster than traditional civil court procedures. For example, recovery of debt due to banks and financial institutions. It is RDD BFI Act 1993. This act was created to help banks and financial institutions recover bad loans efficiently. Before this law, banks had to go to regular civil courts, which often resulted in long delays. The Recoveries Act provides a dedicated legal process for debt recovery, which helps clean up banks' balance sheets and strengthens the financial systems. The next point is a special tribunals or the courts. Alongside the new laws, the government established specialized judicial bodies called tribunals. These tribunals are distinct from regular civil courts and are created to handle specific types of cases. This prevents commercial disputes from getting bogged down in massive backlog of general civil cases. Example, DRT, Debt Recovery Tribunals, and Debt Recovery Appellate Tribunals as well. Debt recovery are primary forums that exclusively deal with recovery of debts owed to banks and financial institutions. They hear the initial cases and are designed to provide a quicker resolution than a regular court. DRATs, Debt Recovery Appellate Tribunals, are the appellate bodies where parties can appeal the decision of debt recovery tribunals. So what is the main purpose of these tribunals? These tribunals were set up to handle a high volume of bank debt recovery cases. By having a specialized forum, they develop expertise and can apply a focused procedural approach that speed up the adjudication and recovery process. This system supports a more stable banking sector and encourages investment by assuring lenders they can recover their dues. And later, to further strengthen this framework, the Commercial Courts Act 2015 was enacted in India. It established commercial courts and commercial divisions in high courts for fast-track handling of commercial disputes above a certain monetary threshold. So, in short, in brief, commercial disputes are crucial to the economy. They ensure they are resolved quickly. Parliament has created special laws and special courts tribunals like DRTs and eventually enacted the Commercial Courts Act 2015 for streamlined adjudication. So, like this, we have other things to be addressed, and the first important point in this context is why commercial courts were needed. What is the necessity? The creation of dedicated commercial courts was a necessary legal reform to handle the unique challenges posed by modern business disputes. The text provided outlines the three main reasons for their need. The first one is high value disputes. Commercial disputes often involve large financial stakes. These cases are not just about a disagreement between two parties. Their outcome can have a major impact on a company's financial stability, market position, and even the broader economy. For example, a dispute over a large infrastructure project or an international trade agreement can involve millions or even billions of dollars. Traditional courts with their heavy case backlogs and slow processes were not equipped to handle financial urgency of these matters. And complexity. Commercial cases are frequently complex, involving intricate legal and factual issues. They require specialized knowledge in areas like intellectual property law, corporate governance, technical contracts, or international trade law. The regular civil court judge may not have a specific expertise needed to understand efficiently resolve these disputes. The creation of specialized commercial courts ensures that these cases are heard by judges with relevant experience, leading to more accurate and quicker judgments. So, the third point is economic impact. What is that? Delays in resolving commercial disputes have a negative economic impact, and a slow legal system can deter both domestic and foreign investment. Businesses, especially foreign investors, look for a legal environment where contracts are certain and can be enforced quickly and predictably. When the legal process is long and uncertain, it increases risk and makes a country less attractive for investment. Therefore, commercial courts were established to provide a faster, more reliable dispute resolution mechanism, which in turn boosts business confidence and promotes economic growth. This was a key factor in improving India's ranking in the World Bank Ease of Doing Business Index. Now it is no more. Now the World Bank's Ease of Doing Business is no more in practice. The amount of commercial disputes earlier was 1 crore and above, but now it has been considered for about 3 lakhs and above. Any contract which is under dispute, which is having a value of 3 lakhs and above, can be filed in the commercial courts. And second most important point is why this act is enacted is because government's aim. What is the aim of the government? The government's primary goal is creating a special mechanism for commercial dispute resolution is to foster a healthy economic environment. This is because the slow traditional judicial process was a major bottleneck for business growth and investment. By establishing dedicated commercial courts and tribunals, the government aims to achieve 3 key outcomes. The first one is improve the business climate. A country's legal system is a critical part of its business climate. When commercial disputes can be resolved quickly and predictably, it gives business the confidence to enter into contracts and make long-term plans. A fast and efficient legal system reduces risk and legal costs, making it easier for companies to operate and expand. This improved environment encourages more trade and smoother business operations, which benefits the entire economy. And second point is attract foreign investors, which is very, very important for our economical growth. Foreign investors are particularly sensitive to country's legal framework. They need assurance that their investments are protected and that they have a reliable way to enforce contracts and resolve disputes. The long delays in India's regular courts has previously made some foreign investors hesitant. By demonstrating a commitment to fast-track commercial disputes, India signals that it is a safe and reliable destination for international capital. This is a crucial step in competing globally for foreign direct investments. And third one is showcase judicial efficiency and independence. The ability to quickly and fairly resolve high-stakes disputes is a testament to the efficiency and independence of nation's judiciary. By creating specialized commercial courts and tribunals, the government is showcasing that its judicial system can meet the demands of a modern, fast-paced economy. This not only builds confidence among investors but also enhances the country's reputation on the international stage as a strong and stable legal jurisdiction. In the same line, so what we have next point is that role of Law Commission of India. Role of the Law Commission of India. What is this? The Law Commission of India played a crucial role in the creation of Commercial Courts Act by conducting a thorough study of the issue and providing an official recommendation. So, the problem identified by the Law Commission is the Commission study confirmed what many in the business world already knew. The existing civil courts were severely overburdened with massive backlog of cases. This overload meant that even high-stakes commercial disputes were getting stuck in a slow multi-year process. The Commission understood that this delay was not just an inconvenience, it was a significant obstacle to economic growth, deterring both domestic and foreign investments. The solution proposed by the Law Commission is that to address this, the Law Commission of India has recommended a specific and targeted solution. The establishment of dedicated commercial courts. The central idea was to create a separate judicial channel to exclusively handle commercial cases. This would ensure that these disputes, with their complexity and economic importance, would no longer be mixed up with ordinary civil disputes. By creating these specialized courts, the Commission aimed to provide a faster, more efficient and more expert-driven process for commercial litigation. This recommendation was a pivotal step, providing the legislative and judicial basis for the government to enact the Commercial Courts Act 2015 and bring this vital reform to fruition. So in the same lines, we have some more important points to be discussed. What is this point? Outcome. What is the outcome of this? Acting on the Law Commission's recommendation, Parliament passed the Commercial Courts Commercial Division and Commercial Appellate Division of High Courts Act 2015. This landmark legislation created a new three-tiered system to exclusively handle high-value commercial disputes in India. What is the new structure? The Act established a clear hierarchy of specialized courts. Commercial courts. These are set up at the district level to handle commercial disputes of a specified high value. Now the value is anything above 3 lakhs is now falls under the jurisdiction of commercial courts. This ensures that a specialized forum is available for these cases right from the outset, preventing them from being mixed with the regular overburdened civil court system. Commercial divisions. For high courts that already have original civil jurisdiction, the power to hear certain cases directly without them first going to lower court, the Act mandated the creation of commercial divisions. These are specialized benches within the High Court dedicated solely to hearing commercial cases, ensuring judicial expertise and focus. Commercial Appellate Divisions. This tier was created to handle appeals from the lower commercial courts and divisions. These appellate divisions are also part of the high courts, ensuring that the entire chain of command for commercial litigation remains specialized, efficient, and focused on speedy resolution. The legal framework provides a structured pathway for commercial disputes for their initial filing to their final appeal, all within a dedicated and expedited systems. So, in simple or in brief, because high-value business disputes were slow and complex, the government decided to set up separate courts to deal with them. The Law Commission recommended this, and it led to the creation of commercial courts in 2015, and ensuring speed, expertise, and investor confidence in the Indian judicial systems. Like this, we have some more important points to be discussed. What is that points? Establishment of special courts. Based on the recommendations of a Law Commission, Parliament enacted Commercial Courts, Commercial Division and Commercial Appellate Divisions of the High Courts Act 2015. So under this, commercial courts have jurisdiction to try all suits and applications relating to a commercial dispute of a specified value. What is this value? Anything above 3 lakhs. The Act also provides for transfer of pending cases to commercial courts from the ordinary civil courts. Amendments into CPC. In order to take this into effect, some amendments were granted in the CPC. What are those? Section 16 of the Act declares that the provisions of CPC 1908 shall stand amended in the manner as specified in the schedule. What is the schedule? The schedule inter alia refers to the following matters: institution of suit, which is section 26, compensatory costs, section 35A, and costs is section 35. Issues and service of summons is order 5. Pleadings, order 6, 7 and 8. Discovery and inspection of documents, order 11. Examination of witness, order 18. Judgment and decree is order 20. Certain provisions were also inserted to ensure speedy disposal of commercial disputes, such as summary judgments, order 13A, and a case management hearing, order 15A, and other ones as well. And other important amendments are Section 35 of the Code of Civil Procedure 1908 is substituted, and it is provided that costs would include fees and expenses of witness, legal fees and expenses, and other expenses in connection with legal proceedings. Special provisions have been made for verification of pleadings. For precision and expediency, specific provisions have been made in Order 7, plaint, and Order 8, written statement. Order 11, discovery and inspection of Code of Civil Procedure has been substituted, and detailed provisions have been made for disclosure, discovery and inspection of documents in suit before the commercial division of a high court or a commercial court. Order 13A, which is summary judgment, has been inserted, setting out special procedure deciding commercial disputes without recording oral evidence. And Order 15 is disposal of the suit at the first hearing. Order 15A, case management hearing has been inserted, which enjoys enjoins the court to hold first case management hearing not later than 4 weeks from the date of filing of an affidavit of admission or denial of documents to frame issues, examine, witness recording of evidence and complete the trial within the stipulated period. To achieve the above objects, necessary amendments have been made in Order 18, hearing of the suit and examination of witness, and in Order 19, affidavits as well. And Order 20, Rule 1 is also amended, requires the court to pronounce judgment within 90 days of the conclusion of arguments. Establishment of commercial courts has amendments made in Civil Procedure Code, thus will go a long way, and by following fast track procedure will try to resolve commercial disputes expeditiously and result in economic growth of the country. And as I have been telling right from the beginning that I am dedicating all these classes to a charitable organization by name ABC Trust, and its UPI number is 9949399898. At the end of this class, a QR code is going to be displayed where you can use the QR code and scan with your phone to make the transfer of 59 rupees, so that your money is going to be utilized for enriching the nutritional benefits of school going children and also for their education. Most importantly is please do not forget to subscribe to my YouTube channel, because the more the number of subscriptions, it is directly proportional to the encouragement for me to make more and more classes in the future. And I thank you very much for this class, and I see you in the next class. Namaste.